Catholic Diocese of Ijebu-Ode. Institute of Marriage and Family. Formation towards Marriage, Family and Human Life Apostolate. Module 1, Theology and Canon Law of Marriage. Lecture 5. The Form of the Celebration of Marriage. 1. Introduction. Before the regulation on the canonical form of celebration of marriage, marriages were celebrated clandestinely, meaning, secretly, without involving the church. This led to a lot of persons entering intermarriage invalidly and without being in fine with the church's understanding of marriage. The canonical form was, therefore, introduced as a way of guaranteeing that person enters into marriage not only validly but also fruitfully, Familiaris Consortia number 68. The canonical form also bears witness to the truth that holy matrimony is a social and surgical act. Furthermore, according to the Catechism of the Catholic Church, the public character of the consent protects the I do, once given, and helps the spouses remain faithful to it, CCC 1631. That which is today understood as the canonical form came into being in 1563 with the Temezi Decree of the Council of Trent, but it was in force only in some jurisdictions within the Church. The extension of this regulation universally was made through the document Natemera of the Sacred Congregation of the Council in 1907, during the reign of Pope Pius X. The 1917 Code of Canon Law adopted this regulation as reflected in Canon 1094, while the same is reflected in Canon 1108 of the 1983 Code. The baptized Catholic who marries without observing the regulations on the canonical form, except if a dispensation from it had been obtained, would be entering into an invalid marriage. According to Canon 1057, a marriage is brought into being by the lawfully manifested consent of persons who are legally capable. For a baptized Catholic, expressing consent with the use of the canonical form of marriage constitutes the lawful manifestation of consent. 2. The canonical form of marriage, Canon 1108. Before going properly into the crux of the matter, it is important to clarify what is meant by the term local ordinary. This term includes the Pope, diocesan bishops, vicars general and episcopal vicars when the law attributes a power to the local ordinary, as is the cases with Canon 111-1, all these authorities are competent to act. But when the law attributes it to the diocesan bishop, as is the case with Canon 1112, the exercise of that power is restricted. Meaning and notion of the canonical form. The canonical form of marriage was introduced by the Church as a way of establishing that a marriage has been contracted according to the law. The canonical form is the exchange of consent by the parties before two witnesses and before the local ordinary or parish priest or those duly delegated by any of them. The two witnesses are required to be physically present at the celebration and must possess the use of reason. They do not have to be Catholics or even Christians. They could be male and female or same-sex. They must be capable of hearing and seeing the manifestation of consent of the parties. Thus, the deaf and one who does not understand the language being used unless there is an interpreter, is not qualified to be a witness. The local ordinary or parish priest or the person delegated receives, in the name of church, the consent of the contracting parties. The one who receives the consent is properly understood as he who assists at the marriage, the officiant. Parish and place for the celebration of marriage, Canons 1115 and 1118. The parish where marriage is meant to be celebrated is well specified in Canon 1116. Marriages are to be celebrated in a parish where either of the contracting parties has a domicile, quasi-domicile, or month-long residence, or, if it concerns vagi, in the parish where they actually reside. With the permission of the proper ordinary or proper parish priest, marriages can be celebrated elsewhere. Such permission to celebrate the marriage outside the parish church of both the contracting parties should be given in a written form. It can be given by the proper parish priest of any of the parties, since both of them are competent to celebrate the marriage. Canon 1118 provides two different regulations on the place of celebration of marriage, one for sacramental marriages, the other for non-sacramental marriages. In the case of two Catholics, the place for the celebration of marriage is the parish church of either of the parties, Canon 1115. In the case of a mixed marriage, it is ordinarily to take place in the parish church of the Catholic party. But with the permission of the local ordinary or the parish priest, it may take place in another church or oratory in an extraordinary situation, and for a just and reasonable cause, the local ordinary can allow the marriage to take place in another suitable place outside a church. Such places could be a non-Catholic church, a hall, or private chapel. The non-sacramental marriage law between a Catholic party and an unbaptized party may be celebrated in a church or in another suitable place. The permission of the local ordinary is not required. On the competence of the local ordinary and parish priest to assist at marriages, Canons 1109 and 1110 provide that the local ordinary and the parish priest can validly assist, with the limits of their jurisdiction, at the marriages of their subjects and those who are not their subject but who happen to be within their territories, as long as at least one of the parties is of the Latin rite for those who are not their subjects, no domicile or quasi-domicile, and have not resided in the territory. For up to a month, Canon 1115. They will need the permission of the parish priest of the parish where they have domicile or quasi-domicile. Personal ordinaries and personal parish priest validly assist, within their territories, at the marriages in which at least one of the parties is their subject. Page 2. Extraordinary form of marriage, Canon 116. The law allows for the valid contracting of marriages before witnesses alone when the person competent to assist at the marriage cannot be present or approached without grave inconvenience. This is what is referred to as the extraordinary form of marriage. The law allows for the use of this form in two circumstances: first, in danger of death, and, secondly, when it is foreseen that the situation will drag on for a month. However, the law adds that where another priest or deacon can be present, he is to be called upon and be present together with the witnesses at the marriage celebration. 3. Delegation of faculty to assist at marriages, Canon 1111. As long as they validly hold their offices, the local ordinary and parish priest can grant general delegation of faculties to assist at all marriages. They can also grant special delegation of faculties, that is, for a single or specific marriage. The one who has been given a general delegation, such as a curate, enjoys the power to sub-delegate it but only for individual cases, cf. Canon 137 No. 3. Even when one has been granted a general delegation, it is unlawful for one to assist at any given marriage without the permission of the parish priest, where possible. The layperson also may be given a general delegation, this is, to be able to act anytime the situation calls for it, or a special delegation, that is, for a specific marriage. To validly grant a delegation of faculties to assist at marriages, the following conditions are necessary. A. It must be given to a specific individual. B. It must be given expressly, not presumed. C. If it is a special delegation, the specific marriage must be identified. It can be done verbally. D. Before a special delegation is granted, the prenuptial inquiry should be carried out to establish the freedom of the parties to marry. Can 1113 E. General delegation is done in writing. If, for example, a priest assists at a marriage outside his territory without delegations, then the marriages is invalid by that very fact. Delegating laypersons to assist at marriages, Canon 1112. According to Canon 1112, where there is a lack of priests and deacons, the diocesan bishop can delegate layperson to assist at marriages, with the previous favorable vote of the Conference of Bishops and after he has obtained the permission of the Holy See. Canon 1116 gives the understanding that the absence of priests or deacons for 1 month is a sufficient motivation to delegate laypersons to assist at marriages. Page 3. There are conditions to be met before a layperson can be delegated to assist at marriages. First, there must have been a prior approval by the Bishops' Conference. Second, the Holy See must give its permission. Third, the delegation is to be made by the diocesan bishop. These conditions are for validity. Note that in the canon regulating the delegation of lay person, the competence is given specifically to the diocesan bishop and not the local ordinary. It is to be noted that the marriages of vagi cannot be celebrated without the permission of the local ordinary. Canon 1071. 4. Duty to establish the freedom of the parties to marry. Canon 1114 provides that the task of ascertaining the free status of the contracting parties to enter into marriage belongs principally to the parish priest of the place where each of the parties has a domicile or quasi-domicile. This is done through the prenuptial investigation carried out by asking each of the spouses, separately, questions that can help achieve this purpose. It is also done through the publication of the Barns of Marriage, cf. Canon 1067. This makes the community aware that the marriage will be taking place and gives the people the opportunity of manifesting any reasonable objection to the marriage and of letting the parish priest know if there are any impediments. The banns are sent to the church of the town of origin of the parties and the church where they are actually residing and are published for 3 consecutive Sundays. If doubts still remain about the freedom of the parties, the parish priest or his assistant is to interview the parents of the parties under oath. Other means could also be used to establish the freedom of the parties. If another person, other than the one who carried out the prenuptial inquiry, is to assist at the marriage, he is to be personally satisfied that the parties are free to marry. 5. Those bound to observe the canonical form, Canon 1117. According to Canon 1117, the obligation to observe the canonical form is binding on all those who were baptized in the Catholic Church or received into it. If a baptized Catholic or one received into the Church enters into marriage without observing this form, the marriage is invalid, except if she had obtained a dispensation from the competent authority for the non-observance of the canonical form. Originally, the 1983 Code of Canon Law exempted those who have, by a formal act, defected from the Catholic Church formed this regulation. This meant that those who have left the Catholic Church by a formal act could validly marry without observing the canonical form. They were also neither bound by the impediment of disparity of cult, cf. Canon 1086 No. 1, nor the prohibition from entering into marriage with baptized non-Catholics without the permission of the competent authority. Canon 1124. The exception was however revoked by Pope Benedict XVI in his Motu Proprio Omnium and Mentem on October 26, 2009. The relevant parts of the document are quoted below. The elimination. I decree that in the same code the following words are to be eliminated, and has not left it by a formal act, Canon 1117 and has not left it by means of a formal act, Can 1086 and 17, and has not left it by a formal act, Can 1124. The modified version. Art. 3. The text of Can 1086 No. 1 of the Code of Canon Law is modified as follows: a marriage between two persons, one of whom was baptized in the Catholic Church or received into it, and the other of whom is not baptized, is invalid. Art. 4. The text of Can 1117 of the Code of Canon Law is modified as follows: the form prescribed above must be observed if at least one of the parties contracting the marriage was baptized in the Catholic Church or received into it, without prejudice to the provisions of Canon 1127 and 2. Art. 5. The text of Can 1124 of the Code of Canon Law is modified as follows: marriage between two baptized person, one of whom was baptized in the Catholic Church or received into it after baptism, and the other a member of a church or ecclesial community not in full communion with the Catholic Church, cannot be celebrated without the express permission of the competent authority. The implication of the above provision is that it is no longer possible to leave the Church with a formal act. Even those who have left the Catholic Church for other churches are still considered Catholics and are, therefore, bound to the canonical form of marriage. As such, they marry invalidly if they fail to observe the canonical form, except a dispensation has been obtained. The other side of the coin is that because the marriage is invalid, if they get a divorce, they can easily marry someone else in the Church. It also provides a basis for those who have left the Church for other churches to rightly request that their marriage be celebrated in the Catholic Church. The revocation of the exemption is founded on the theological principle: Simul Catholicus, Semper Catholicus, once a Catholic, always a Catholic. 6. The rite and recording of marriage. Rites of marriage. Canon 1119 and 1120. The approved rites for the celebration of marriage, as found in the liturgical books, are to be observed. However, in cases of necessity, one is not bound to use them. Such cases of necessity include when one or both parties are in danger of death, Canon 1116, or when a party has been dispensed from observing the canonical form. Canon 1120 allows the Conference of Bishops to produce its own rite of marriage that harmonizes the culture of the people and the Christian spirit. This, however, has to be reviewed by the Holy See. According to this canon, such adaptation must not fail to take cognizance of the essential legal requirement of the law, Canon 110 No. 2. Recording of marriage, Canon 1121.
According to the provision of Canon 1121, it is the responsibility of the parish priest of the parish where the celebration of the marriage took place to ensure that all the necessary details about the marriage are entered into the marriage register. If the marriage was celebrated according to the extraordinary form, Canon 1116, priest or deacon present or, in the absence of such, the witness present are bound to inform priest or local ordinary about the marriage so that details of it can be recorded. In the case of a marriage celebrated with a dispensation from canonical form, the local ordinary who granted the dispensation is to ensure that both the dispensation and the celebration are recorded in the register of both the curia and that of the parish of the Catholic party. After the celebration, the Catholic party is to give all the necessary details about the celebration to the local ordinary and his or her parish priest. In addition to entering it into the marriage register, the parish priest of the place where the marriage took place has the responsibility of ensuring that the details of the marriage are entered into the registers in which the baptism of the spouse has been recorded.
Canon 1122.
If a spouse did not contract marriage in the parish in which the person was baptized, the parish priest of the place of the celebration is to send notice of the marriage as soon as possible to the parish priest of the place of the conferral of baptism.
This obligation is not there if one of the parties was baptized in a non-Catholic church. Recording cases of validation, declaration, of nullity and dissolution, Canon 1123. Finally, according to Canon 1123, whenever a marriage is validated in the external forum through renewal of consent, Canons 1156 to 1160, or retroactively, Canon 1161 to 1165, or declared null, Canon 1685, or dissolved because of non-consummation, Canon 1142, or in favor of the faith, the parish priests of the place of the celebration of the marriage and the place where the parties were baptized must be informed so that a notation is properly made in the marriage and baptismal registers. 7. Conclusion. As we have clearly seen, the thorough observance of the required form for the celebration of marriage is essential for the valid celebration of those marriages. As marriage facilitators in our various parishes, this is an area that requires serious attention. It is the duty of marriage facilitators to assist those preparing for marriage in meeting up with those formal requirements that concern them. This way, we will be collaborating with the parish in ensuring that nothing stands in the way of the valid and fruitful celebration of marriages. John Hewells, a renowned canonist, draws a list of the ways the form for marriage may be defective and, as such, invalidate a marriage. 1. Neither party is a Latin Catholic. 2. One or both parties did not manifest consent to marry the other by words of sign. 3. There were no witnesses or there was only one witness. For either of the two witnesses lacked the use of reason, or was incapable of hearing or seeing the manifestation of consent, or could not understand what it meant. 5. The officiant did not assist actively by asking for and receiving the consent of both parties.
6. The officiant lacked the use of reason at the time of the assistance.
7. The officiant was in substantial error or ignorance about what he was doing. For example, he thought he was only doing a rehearsal instead of the actual wedding.
8. The officiant was forced into assisting.
9. The officiant was outside his territory and lacked special delegation.
10. The officiant had a personal jurisdiction but neither of the parties belonged to that personal jurisdiction. 11. The special delegation had not been given expressly to a specified person. 12. The special delegation had not been given for a specified marriage. 13. Someone with a special delegation for a marriage sub-delegated the faculty to another without the authorization of the one who had granted the special delegation. 14. The officiant was not in full communion with the Catholic Church or had been suspended or excommunicated and the penalty was imposed or declared. 10. John Hewells, The Pastoral Companion, a Canon Law Handbook for Catholic Ministry, 4th updated edition, Montreal, 2009.
Catholic Diocese of Ijebu-Odi. Institute of Marriage and Family. Formation towards Marriage, Family, and Human Life Apostolate. Module 1, Theology and Canon Law of Marriage. Lecturer, Reverend Father David Mary Odunsi. Topic: Provisions of the Nigerian Law on Marriage. Preamble. The marriage institution in Nigeria. In Nigeria, as a political entity and sovereign state, there are broadly three recognized kinds of marriage. A. Marriage under the Act or statutory marriage, also known as marriage under English law. B. Marriage under Islamic law, and E. Marriage under native law and customs. Under the first kind, fall Christian marriage and marriage recognized under the civil law. Islamic marriage generally can fall under this kind of marriage, but at the same time, it can fall directly under the second kind, which is marriage under Islamic law. The third kind includes all marriages celebrated following any of the native laws and local customs recognized in Nigeria, ordinarily called traditional marriage. However, Islamic marriage can also fall under marriage under native laws and customs for Muslims, provided it can be established as such. Marriages under each of these three systems carry their incidents and create different rights and obligations as applicable. Our concern, here, however, is marriage under the Act, in which no one is left in doubt as to the requirements and general provisions. 2. General provisions on statutory marriage in Nigeria. A statutory marriage is a marriage contracted in accordance with the provisions of the Act. A valid statutory marriage must satisfy the 6 essential factors required for a marriage or risks the marriage being void or voidable. They are A. Previous marriage bond, B. Consanguinity or affinity, E. Lack of the required form, D. Lack of consent of the parties, E. Impotence, F. Insanity or mental incapacity. Bigamy or previous marriage bond. MCA 3(1)(a) provides that none of the parties to the marriage should be legally bound by any previous marriage at the time of contracting the present marriage. In Oja v. Oyai, the High Court ruled that where there is a customary law marriage with one person, and the customary law spouse seeks to marry or marries another person under the statute, the second marriage constitutes an offense known as bigamy. Prohibited degree of consanguinity or affinity. Consanguinity is understood as a relationship by blood, while affinity is a relationship by marriage, which include the blood relatives of one's spouse. Marriage under the Act is void if it involves persons who are within the prohibited degree of consanguinity or affinity. Section 3 of the first schedule to the MCA draws up the prohibited degrees of consanguinity and affinity. Hence, marriage of a man is prohibited if the woman is or has been his ancestress, wife's mother, descendant, wife's grandmother, wife's daughter, sister, father's sister, mother's sister, brother's daughter, wife's son's daughter, wife's daughter's daughter, sister's daughter, father's wife, grandfather's wife, son's son's wife, daughter's son's wife. Marriage of a woman is prohibited if the man is or has been her ancestor, descendant, husband's father, husband's grandfather, brother, husband's son, father's brother, mother's brother, husband's daughter's son's son, husband's daughter's son, mother's husband, daughter's husband, brother's son, grandmother's husband, son's daughter's husband. It then adds that for the purpose of this schedule, it is immaterial whether the relationship is of the sister's son whole blood or half blood, or whether it is traced through or to any person of illegitimate birth. Lack of the required form. This is when the marriage takes place without complying with the law of the place where it is celebrated regarding the form for the solemnization to be observed. Section 33(2) of the Marriage Act expatiates on this. Section 3(1)(b) Matrimonial Causes Act 1970. A marriage shall be null and void if both parties knowingly and willfully acquiesce in its celebration, in any place other than the office of a registrar of marriages or a licensed place issued under Section 13 of this Act, or under a false name or names, or without a registrar's certificate of notice or license issued under Section 13 of this Act duly issued, or by a person not being a recognized minister of some religious denomination or body or a registrar of marriages. Lack of consent of the parties. The law requires the parties to the marriage to give their full and real consent to it. Unreal consent is understood as any consent obtained under duress or fraud. That party was mistaken as to the nature of the ceremony or as to the identity of the other party. That party is mentally incapable of understanding the nature of the marriage contract. Furthermore, the Marriage Act provides that if either party to an intended marriage, not being a widow or widower, is under 21 years of age, the written consent of the father or if he is dead or of unsound mind, or absent from Nigeria, the mother, or if both be dead or of unsound mind or absent from Nigeria, of the guardian of such party, must be produced and annexed to such affidavit as aforesaid before a license can be granted or a certificate issued, MA Section 18. Non-age. Marriage under the Act is void if either party to the marriage is not of a marriageable age. However, the Act did not define the term marriageable age. In the absence of statutory definition of the age of marriage, the court may have recourse to the common law rule on the subject to determine when a party to a statutory marriage is of marriageable age. Under the common law, marriageable age is the age of puberty 14 years in the case of a boy and 12 years in the case of a girl. From the previous condition, however, the law seems to favor 21 years as the legal age of marriage in Nigeria. Impotence. A marriage under the Act is voidable if either party to it is incapable of consummating the marriage. The Act speaks of impotence or non-capacity to consummate the marriage without defining it further. In proving the validity or invalidity of a marriage involving non-consummation thereof, the judge decides upon reasonable evidence. Insanity or mental incapacity. Insanity voids a marriage as stated below. Either party to the marriage is of unsound mind, or a mental defective, or subject to recurrent attacks of insanity or epilepsy. Thus, this section of the Act voids a marriage if one of the party at the time of the marriage suffers from some venereal disease. The Act goes ahead to define a mental defective as a person who, owing to an arrested or incomplete development of mind, whether arising from inherent. Section 3(1)(e), Matrimonial Causes Act 1970. This is similar to the provision of Canon 19 of the Code of Canon Law on gray areas, where the law is silent on certain rooters. Two of its four alternatives, laws enacted in similar matters, and the jurisprudence and practice of the Roman Curia seem applicable here. Page 3. Emuses induced by disease or injury, requires oversight, care or control for his own protection or for the protection of others, and is by reason of that fict, unfitted for the responsibility of marriage. MA Section 5, 2. 3. Procedures for contracting statutory marriage. We divide the procedures for contracting statutory marriage in Nigeria into three: preliminaries to marriage, celebration of marriage, registry, and evidence of marriage. 3.1. Preliminaries to marriage. In the first place, a notice of marriage shall be signed and given to the registrar of the district in which the marriage is to take place. This is Form A in the first schedule according to the Matrimonial Causes Act. The Form B is for those who cannot read or write, in which thumbprinting is allowed. This notice of marriage shall be published in the registry by the registrar usually for 21 working days, but not exceeding 3 months. Form C is issued upon the payment of sums, prescribed fees and satisfaction of some requirements as to the domicile, age, and freedom from impediments of the parties to the marriage after the 21 working days or 3 months of publications of the notice of marriage. A certificate or license to marry shall be issued to the effect that there are no caveat, let him beware, or objection to the marriage, and authorizing the celebration of the marriage by either the registrar or a recognized minister of a religious denomination in a recognized place of worship. This is the Form D in the first schedule according to the Matrimonial Causes Act. Note that after publication, but before the issuance of the registrar's certificate in Form C, any person who has just reasons why the parties should not get marriage can enter a caveat against the issuance of the registrar's certificate by writing the word forbidden opposite the entry of the notice in the marriage notice book. The person must include his or her name, address, and the grounds for the objection in compliance with the provision of Section 14 of the Marriage Act. Where such a caveat is validly entered, the registrar shall not issue his certificate until the caveat is removed by the judge of a high court of the state to whom such a matter shall be referred to for determination. The judge shall cause the parties and the caveator to appear before him to show why the registrar's certificate should not be issued or otherwise, and the matter shall be determined in a summary way with the right of appeal to the Court of Appeal. 3.2. Celebration of marriage. For an intended marriage for which a license has been received, it shall take place either in the registry solemnized by the registrar or in a licensed place of worship by any recognized minister of the church, using the religious rites of such a denomination. If the marriage is to take place at the marriage registry, it shall be celebrated between the hours of 10 a.m. and 4 p.m. If in a place of worship, such a marriage must take place with open doors within the hours of 8 a.m. and 6 p.m. in the presence of 2 or more witnesses besides the officiating minister. A minister shall not celebrate any marriage if he knows of any just impediment to such marriage, nor until the parties deliver to him the registrar's certificate or license issued under Section 13 of the Act. After the marriage has been celebrated, the officiating minister, together with the couple and the witnesses, shall immediately fill out and sign the marriage certificate. It is usually in triplicate. The minister shall sever a copy and send it back to the marriage registry within 7 days of the celebration of the marriage. This is the Form F in the first schedule. The book of marriage certificate is gotten from the registry, usually at some prescribed price. A marriage may be celebrated in a place other than a licensed place of worship or the registrar's office if a license issued by the minister under Section 13 of the Marriage Act so directs. Thus, a marriage may be celebrated in a town hall, garden, or some other places so indicated in the license issued by the minister. But such marriage must be contracted by a recognized minister of some religious denomination or body, or by the registrar of marriage in compliance with Sections 23 and 29 of the Marriage Act. After the celebration of the marriage, the officiating minister shall issue a marriage certificate in Form E, duly signed by the minister or registrar, the parties to the marriage, and their witnesses. Interestingly, the Code of Canon Law, Canon 1118, paragraphs 2 and 3, also makes similar provisions. 3.3 Registry and Evidence of Marriage. It is required of the registrar to register the marriage celebrated in the marriage register book in her office and within 10 days, send to the principal registrar a certified copy of all entries on marriage during the month. 4. Every certificate of marriage which shall have been filled in the office of the registrar of any district, shall be admissible as evidence of the marriage to which it relates in any court of justice or before any person having, by law or consent of parties, authority to hear, receive and examine the evidence, for instance, arbitrators in alterative dispute resolutions, ADR, or in some cases, marriage tribunals. 4. Sanctions and punishments for violations. There are sanctions and penalties for the violation of the requirements of the law of the country on marriage, and since ignorance of the law is not an excuse, both those intending marriage and those assisting such marriage need to acquaint themselves with such provisions of the law. These offenses and their penalties are spelled out in Sections 39 to 48 of the Marriage Act. Thus, a marriage with a person who is previously married attracts 5 years imprisonment. By making false declaration for marriage 5 years imprisonment, false pretense of impediments to marriage 2 years imprisonment. Unlawful performance of marriage ceremony 5 years imprisonment. E. Willful neglect of duty to fill up or transmit a certificate of marriage 2 years imprisonment. F. Personation in marriage 5 years imprisonment. G. Fictitious marriage 5 years imprisonment. H. Contracting marriage under the Act when already married under native law, if the marriage is not by the same parties, 5 years imprisonment. 1. Contracting marriage by native law and customs, to another person, when already married under the Act 5 years imprisonment, marrying a minor without the prescribed content 2 years imprisonment. J. Contracting marriage by native law and customs, to another person, when already married under the Act is 5 years imprisonment, marrying a minor without the prescribed content is 2 years imprisonment. 5. Dissolution of marriage. Dissolution, according to the Oxford English Dictionary, is the formal closing down or ending of an official body or agreement. Dissolution of marriage, therefore, is the formal ending of a marriage contract. The plurality of marriage systems in Nigeria is also reflected in the dissolution of marriages in Nigeria. Apart from the fact that different courts are seized with jurisdiction on matrimonial causes for the different types of marriage, and the incidents and consequences of dissolution are also different. 5.1. Grounds for dissolution of statutory marriage. Marriage under the Act can be dissolved if it had broken down irretrievably, proved upon the following grounds stated in sections 15(2) and 16(1). The grounds mentioned in the above sections. Matrimonial Causes Act Section 33 are symptomatic of a broken-down marriage. A court can only dissolve a marriage when one of the facts under Section 15(2) is established to its satisfaction. All a petitioner for matrimonial relief may need to prove to establish an irretrievable breakdown of marriage, therefore, is one of the facts under Section 15(2). The grounds can be identified as follows: A. Non-consummation, B. Adultery, C. Intolerable behavior, D. Desertion for 1 year, E. Separation for 2 years, 1. Separation for 3 years, G. Non-restitution of conjugal rights, H. Presumed death, i.e. rape, sodomy, or bestialities, habitual drunkenness, X. Imprisonment for 3 years, 1. Attempted murder, M. Attempted or factual serious injury on the petitioner by the respondent, M. Insanity. 5.2. Jurisdiction to dissolve statutory marriage. Under the Matrimonial Causes Act 1970, the basis for jurisdiction in matrimonial causes is domicile. See Section 2(2) of MCA, which provides that proceedings for a decree of dissolution of marriage under the provisions in paragraphs AF may be instituted by any person domiciled in Nigeria. However, because domicile is fundamental to the issue of jurisdiction, without which the court will not have the powers to adjudicate the matter before it, it is important to understand what is domicile in matrimonial causes. Domicile is important, at least in the common law world, because it connects a person to the legal system of a given jurisdiction. It is the basis upon which a person may pursue a legal process, for example, matrimonial causes, succession, legitimacy, etc. Between married couples, the wife acquires the domicile of the husband upon marriage. This means that whenever the wife wishes to undertake matrimonial proceedings, she must do that in a court within the jurisdiction of the husband's domicile. The implication is that a wife who is normally resident in Nigeria cannot seek matrimonial relief in Nigeria where the husband has changed domicile by relocating to Ghana, since the wife's domicile is tied to that of the husband. To cure the problem of circumstance, when a husband may deliberately change domicile to make it impossible for a deserted wife to seek matrimonial relief, the Matrimonial Causes Act under Section 7(a) provides that a deserted wife who was domiciled in Nigeria immediately before the marriage, or immediately before the desertion, shall be deemed to be resident in Nigeria. Paragraph B also provides that a wife who is resident in Nigeria at the date of instituting proceedings under the Act and has been so resident for 3 years immediately preceding that date shall be deemed to be domiciled in Nigeria at that date. Lecture by Reverend Father David Mary Odunsi.